People often wonder how property will be divided when they get a divorce. This depends on your specific circumstances and the laws of your state. Generally, spouses are allowed to keep their separate property, assets they owned before the marriage, and gifts or inheritance they received before, during, or after the marriage. Property acquired during the marriage, such as income, savings, retirement accounts, stocks, bonds, cars, homes, and furnishings, is considered shared property and divided between the spouses. The method of division depends on whether your state follows community property laws or equitable distribution. In community property states, the court splits shared property and debts 50-50, although exceptions can apply. If you divorce in an equitable distribution state, the court tries to divide your assets and debts fairly, but not necessarily equally. A judge weighs numerous factors, which generally include how long the marriage lasted, the spouse's ages and health, their earning capacities, and whether each spouse has significant separate property. You and your spouse can try to negotiate an agreement and submit a property settlement for court approval. But the more complex your marital estate, the more you can benefit from an attorney's knowledge to reach a fair and enforceable agreement. Finally, a court will usually enforce a valid prenuptial agreement that governs the division of marital property. If you have questions about property division in your state, a local divorce attorney can provide specific guidance.